In a workers' compensation claim to determine weekly benefits due an injured worker, how should an employee's average weekly wage be calculated when the employee works at 3 different jobs? That was the question in the case of the average weekly wage. In this case, Wheeler worked at the Cinnabon store in the mall in Sioux Falls. She was also employed at a casino, and her 3rd job was at a convenience store. Wheeler held all jobs concurrently so she could reach full-time employment, and had done so on a long-term basis with plans to continue. After injuries at Cinnabon, she was unable to work at Cinnabon as well as her other 2 jobs. Wheeler claimed her wages from all 3 jobs should be used to calculate her average weekly wage. Temporary disability benefits in South Dakota are based on 2/3 of an injured worker's average weekly wage. Although a majority of jurisdictions in the United States aggregate earnings in some manner, the South Dakota Supreme Court had never addressed the issue until May of 2015. How would you decide this case? Should the employer be responsible for benefits based upon the aggregate of its employees' wages for all jobs in which she engages? We'll be back in a moment to answer that question. Should an injured employee's average weekly wage include all wages from all jobs in which the employee is engaged to determine his average weekly wage? Yes, said the South Dakota Supreme Court. The court reviewed statutes governing workers' compensation benefits, which included a definition of earnings as the amount of compensation for the number of hours commonly regarded as a day's work for the employment in which the employee was engaged at the time of his injury. The court agreed that the language of the statute was ambiguous. So, the court followed its rules of statutory construction and earlier cases which have held that the primary purpose of workers' compensation is to fairly compensate the employee for his or her loss of income earning ability. The court held that Wheeler's wages from the total of all 3 jobs would be used to determine her benefit. While insurance companies might be forced to set higher premiums, the loss to the injured employee would be greater. The court recognized that it is the worker who alone bears the burden of losing not only the wage from the job where he suffered the injury, but also his wages from his other concurrent employments. Remember, it's a matter of law.